We start our meetings with the Pledge of Allegiance to the flag. If you can stand, please. Bobby Don is going to lead us.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Susan, would you mind going and asking them to turn off? Okay. Thank you. Doug is going to introduce to you our speaker for tonight, and she's going to use the
Okay.
very loud.
Should we speak up here?
Wherever she.
Yeah, here.
Wherever you like.
Well, you can come on up.
Okay,
Yeah.
I'll come on up. Thank you.
We don't have
Since I've never made it
That's
before, it won't be
okay.
a
I've been
long
sitting on
meeting.
one all day. It's okay. Thank you, though.
Superior Court Judge Amanda Mysterio.
Yes, that's me. Thank you. All right, I'm actually pretty loud on my own, but I'm happy to use the mic. In fact, some people will tell you maybe I'm loud because I yell a lot. That's not true, but I do have to talk loudly sometimes because I said today sometimes getting everybody to where they need to be in a courtroom is a little like herding cats because usually if the attorneys are talking and they're trying to work things out, which is common. So I'm used to talking to a lot of people, but I tried to think of some things that I thought you guys might find interesting. I know Judge Weaver, our chief judge in our circuit, was here. I'm not sure when she was here, but maybe back in the spring or last fall. But I'm sure she talked to you kind of about her baby, which has been our accountability courts, which is our drug court, our mental health court, our veterans court, parental accountability courts. We have a DRC Light program. We have a number of different courts. Those are all part of the Criminal Justice Reform Act that some of you probably heard about. It is with a focus and intent on kind of, frankly, reforming the criminal justice system and how we deal with folks who come into that system and realizing that a lot of the problems and a lot of the trouble that people get into is kind of systemic if you don't treat some of those underlying issues. We're kind of in a vicious cycle. So we are at the forefront, quite frankly, this circuit, because we have Chief Judge Brenda Weaver, of having all those courts. So I know she talked to you about them. I'm not going to talk to you about that tonight since she did, unless you have questions. And if you do, I'll be happy to answer those. Because there are 3 Superior Court judges in the circuit, the Appalachian Circuit meeting consisting of Fannin County, Gilmer County, and Pickens County, which means that we spend a third of our time basically in each of those counties. So any given day, we could be in any one of those counties. For example, today Judge Weaver and I were in Gilmer County, Judge Bradley was out here in Fannin County, and it's just kind of how we ride the circuit. But Judge Weaver and I do the accountability courts. We divide those up. I have a mental health court because we have discovered that is an issue that comes up very, very frequently in both civil and criminal cases. So I have the mental health court, and then Judge Weaver and I take turns doing some of the other courts. If one of us is not available, the other one picks up, because our court dates are always on the same day, so it's easy for us to overlap if necessary. So if anybody has questions about any of the accountability courts, I'll be happy to answer those for you. But since she talked about that, I'll move on. Some of the things that I thought I might talk about is we have a number of different courts, and somebody already asked me, what type of judge are you? And there are lots of different types of judges, and so I thought I would kind of give you an overview of some of the jurisdiction that we have and kind of tell you some of the things that we do, why you see certain cases go one way versus another sometimes. Can't talk to you about any specific cases. I can't answer questions about that, but I can give you, general understandings of why certain cases move a certain track versus others. One of the things that we do as Superior Court judges is we are truly a general jurisdiction court. What that means is that we hear everything. We have jurisdiction to hear basically everything in our courts. Now that doesn't mean that we do hear everything, because obviously we have juvenile courts that hear juvenile matters. We have probate courts that have a very specific jurisdiction. We have magistrate courts that have a very specific jurisdiction. But Superior Courts, on the criminal side, we hear everything from speeding tickets, which is odd because most people don't think Superior Courts do that, and frankly, many jurisdictions, they don't. They have other courts that deal with that. We're just not big enough to have a separate state court to handle some of those. So because of the size of our circuit, and it's based on our population of the entire circuit, our Superior Courts have everything, basically. So we can take a speeding ticket, we can take a capital murder, a death penalty case. That's the jurisdiction. Anything from a speeding ticket to a the death penalty on the criminal side. On the civil side, it's anything you can think of. We have everything from domestic cases to property disputes to contract disputes. Things get appealed to us out of some of the lower courts, and we have to deal with those, and those are done, almost like what we would call a de novo review, which is basically they come up out of that court and we start all over in Superior Court if it's an appeal. And we do that with several different of the lower courts. So on any given day, somebody asked me this earlier, they said, well, how does your typical week go, something along those lines. Well, today, like on a Monday, we will meet, Judge Weaver and I will meet on a Monday. We will go through all of our accountability courts, every participant and every accountability court that we have, and there are, I don't know, at this point, probably a couple hundred of those. Not courts people. But we have to go through every single one of those cases. Every single one of them before we go to court, because that's part of our state requirements, is that we review and talk about all those participants before we get to court. So on Monday, like yesterday, we started at 9 and finished at 6, basically. And we were there all day working through lunch, going through those with our entire team. And our team has about 15 or 20 people represented from the public defender's office to the district attorney's office, probation, both state and county. We have treatment providers, we have case managers. That's a Monday. Then Tuesday, Wednesday, and Thursday of that week, we'll what we call ride the circuit, which means on Tuesday we'll be in Gilmer County. Judge Weaver would be doing civil, I would be doing criminal, or vice versa. And then we would do that Tuesday in Gilmer, Wednesday in Pickens, and Thursday in Fannin. Then Friday, depending on what's going on, we would have what we would probably call a special set day, where somebody said, Judge, this is going to take a little while, and I don't think we can hear it with the other number of cases you have that day, and so we'll set something on that Friday a lot of times to be heard. Or if it happens to be the Friday before a trial week, then we'll have motions and pleas and things like that heard if it's a criminal week, or we'll have pretrial conferences, things of that nature. This week, typical week, I had probably, I don't know, maybe 13 or 14 cases on my calendar today in Gilmer County. That doesn't sound like a lot, but if each one of those takes 2 hours, which is not uncommon, you can see how we have time issues sometimes, because everybody wants their day in court and everybody wants to be heard. So we have to be very, very, very specific about time management. I'm very specific about time management, so we have to manage that and try to get everybody heard the best way we can. And a lot of those cases will resolve. But we're dealing with that. In addition to that, Judge Weaver and I, before we even start that calendar, come in earlier and start our Veterans Court, our Mental Health Court, our Drug Court. We do our other docket before we start that. So then we'll finish that, and then the next week, I have trials. I have jury trials there in Pickens County, so I'll have criminal jury trials. The next week, we'll start over, but then Judge Weaver will be doing civil, and I'll be doing criminal. And we have another judge. We have Judge Bradley. He's on a completely different day, and he's the reverse of us. So while I'm in one county and Judge Weaver's in one county, he may be in another. When Judge Weaver and I are both in trial weeks, she's probably in one county, I'm in one county, and he's in another county. In addition to that, we have a juvenile court judge, our chief juvenile court judge, who does sit by designation as a Superior Court judge to help us do some of the things that if we had to take all of those cases, quite frankly, it'd be very difficult for us to get it all done, because our calendar is pretty massive, because obviously we handle all that jurisdiction. We are not big enough to have a state court, so we don't have anybody to filter it out to. So we have to kind of just do the best we can with it. But we have a very specific court calendar that we sit down once a year basically, and kind of filter out how we're going to break down our years. And we have to have trial weeks for criminal and civil in Pickens County, and Fannin County, and Gilmer County. And the only way to do that is about every other week. This is what it works out to. So we are constantly either in civil non-jury, criminal non-jury, or jury trial. And if you happen to have an accountability court like I do, all your other days are probably taken up doing something with that, because we have to have incredible amounts of training. I feel like I need to go back and maybe get like a psychology degree or something, because I have a mental health court. Sometimes I don't understand all the lingo that's being used, and we go to lots of training to try to help us learn what we need to know about that. So in addition to having a law degree, we have to keep going and learning to keep up with that. And of course, those are very specific populations, and they require a lot of work for us to deal with. Now, some of the questions that we get a lot, and I thought that I might talk about this, and if anybody has questions, I'd be happy to answer them, is why do certain cases go quickly versus some other cases don't go quickly? Civil cases in particular, because civil, I'm going to start with civil, and then I'll talk about the differences between civil and criminal, and why you see some like civil cases take, because we have cases that are civil that are very old. And by old, I mean 4 or 5 years. And a lot of people want to know why. Well, a lot of that is because there is constant, from the time that it is filed, there are constant things moving. We just don't always get them until they're ready for court. Now, there is a time frame for which the attorneys can do certain things, meaning from the time it's filed till an answer is filed, there is a 6-month window, basically, for them to do all the discovery and things that they need to do, figure out what's going on in the case. Almost invariably, it never lasts 6 months. There's always, Judge, we need an extension. We need a 3 to 6 month extension. Of course, you may only get twice a year in Fannin County to try a civil case, because I still have criminal and I have 2 other counties. So there may be only 2 or 3 civil trial weeks a year for my calendar. So you have to hit one of those weeks to be able to be ready, and that's true for all the judges, and that's because there's only 3 of us and we have 3 counties. And we have to have criminal and civil trials in every county. So by the time you do our civil non-jury days and those, you're looking at a very specific window, but the attorneys know a good year in advance basically what those weeks are, and they know that they need to be getting ready for them. There are things in civil cases that can speed them up. There are things that we call motions for summary judgment. You can file one of those if you have a basis to do that, and basically what those are, those can end the case. Even though somebody's demanded a jury trial, even though somebody says this needs to go to a jury trial, if you fall into these certain categories and there's no argument, and that motion for summary judgment is granted, it's exactly what it says. It's a summary judgment. It cuts it off, even before it gets to a jury trial, even if somebody asks for one. Because it basically is saying there are no facts that are in dispute. Everybody agrees what the facts are, and the law is this, it's over. If we do that, the next step is it goes to the appeal process, and of course we have the Court of Appeals and the Supreme Court, and I'll talk a little bit more about them in just a minute, but they go from us to either the Court of Appeals or the Supreme Court of Georgia, not the United States, but the Supreme Court of Georgia. I have had one attempt to go to the Supreme Court of the United States, and those are obviously very limited circumstances, but and then the Supreme Court or Court of Appeals will get it depending on what the case was. It depends on which one it goes to, depending on what the case was. They'll say, yep, that was right, case over. That can make a civil case go very quickly, because obviously that motion just resolved the whole thing. So we get a lot of those. There is no counterpart to that in the criminal court. Many people think that a judge can just go, that's a terrible case, dismiss it. Can't do it. There is no equivalent to that in a criminal case. And there are lots of reasons for that. But in a criminal case, because there are very specific due process issues that have been set in stone forever, there's no real summary method for that. Now, that is not to say there aren't times where cases are dismissed early, and it's based on certain types of motions that are made. But there is no authority for me as a judge to just look, unless the DA and PD's office agree. If I get a case and I see this case and I'm going, okay, these are not good facts, I don't know, the law's not here, I can't do a thing about it except either try it or see if it works out. Unless somebody brings me a motion, like for example, maybe the indictment is flawed. That happens sometimes. There's a problem with the indictment is flawed, the attorney makes a motion, that can cause the case to go away. But only temporarily, probably, because it can be reindicted under certain circumstances. So the criminal process is very different. There are very limited opportunities in a civil case to appeal mid-case. Meaning, if the case is in the middle of a civil case and something happens, just because the judge makes a particular type of decision does not mean that you can have what we would call an intermediate appeal. All right, there are some cases you can, and they can also ask to be given special permission to do that, get what we call a certificate of immediate review, saying, Judge, this is so important, and we think you screwed up so badly that we want to take this up right now and see what the Court of Appeals or the Supreme Court, would say about this. That happens occasionally, and we grant them, and they take them up, but sometimes they don't take them. They say, no, we don't agree. Go ahead about your case, and we'll see what happens at the end. There's very little of that in civil cases, because when the decision's made, it's just made and you move on with the case, unless there's one of those very limited circumstances of an appeal. In a criminal case, however, there are lots of things that are appealed right in the middle of the case. That is a very common thing. That is a common thing, regardless of whether it's civil or criminal. If it goes up to appeal to the Court of Appeals or the Supreme Court, I no longer have jurisdiction over it, which means I can't touch it. They have it, they have to do whatever they're going to do, and they have to send it back to me before I can do anything with it. Because basically what has occurred is I've made a decision, whether it's right or wrong, they're going to decide that, and until that decision is made by some court higher than ours, I'm stuck. And that, I mean, and the attorneys are stuck. We literally have no jurisdiction any longer. It's up, it's gone, we'll get it back. Sometimes we get them back, you know, 6 or 8 months, sometimes it's 10 or 12 months. It just depends on when it is filed and how long it takes them to docket it and get it back to us. There are things in a civil case that can cause issues. For example, when you're trying to take depositions and the attorneys are trying to get their schedules to work out and you can't get them to work out, sometimes that's very difficult to get those cases moving because there's a definitive time for things, and if they let the time run, then they have to come and say, whoops, we let that time run, can we have some more time to do this? That happens a lot. We try to keep our cases moving, both civil and criminal, but there are a lot of things that can occur that can be very unforeseen that people don't, you know, always hear about, but they're there. In civil cases, it can happen a lot because a lot of times it'll deal with like expert witnesses. They'll have to go find a new expert, and those are not always easy to find in a particular area they're looking for, particularly if you're getting into some complex like products liability issue or something like that. You know, this is a small area, so they have to go usually looking somewhere else to find those experts, and that can take a while. So there are things that we have to do to keep the case moving. During the weeks, like this week, we wouldn't be hearing any jury trials, or at least I'm not, and I don't think Judge Bradley is either, but none of us are hearing jury trials this week, but what we are doing is hearing all those motions we were talking about. This week it's civil for me, so all these cases that are pending, whether they're a tort, a personal injury, or some kind of contract case, we're hearing motions on those this week, so that when we do get to a trial point, I had one today where we had to lay out some very specific times so that we could be ready for the trial term in the springtime, which will be my next trial term in that county. And I was telling them, you need to do this, 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 and this, so that come, you know, whatever it is, February, March of next year, you can be ready to go. Because, you know, you're like, wow, February, March, that's a long time. In the legal world, that's not a long time. We don't have, sometimes our version of time and everybody else's version of time are not the same things. You know, the attorneys come in and they'll say, Judge, it's going to take an hour to be heard. An hour in lawyer time is like, you know, 6 hours later. Because we just, you know, we don't think in time like everybody else does, I don't think. So we have, you know, it doesn't sound like a long time. I mean, it actually sounds like a long time. You think, gosh, that's a long time to go without a trial. But in the legal world, that is a very small window because they have a lot they have to accomplish. Now, one of the things that's going to be interesting this year, and I say this year because it's an election year, and I'm sure most of you know this, but obviously we have the Georgia Supreme Court, we have a Court of Appeals, and this was on, we have a legal instrument that we get like every day that kind of tells us the news in the legal world. It's called the Fulton County Daily Report. This is the second article that's appeared on it recently. Judges in Georgia are elected. Okay, we are all elected. However, some are appointed initially because of when the seat opens up. So I was appointed initially, but then I had to run after that. That's very common for judges to be appointed because if somebody retires midterm or leaves midterm, that the governor appoints. The Georgia Court of Appeals and the Supreme Court, there have been 2 articles about this recently. Whoever becomes your next governor and our next governor is going to have a tremendous impact on the judiciary. The reason is because the Court of Appeals and the Supreme Court, we have 2 justices on the Supreme Court right now who are going to turn 75 during the next term, but before the next election. All right? Now, what does that mean? That means they have to retire midterm. Okay? Because if they don't, they lose their pension. So they must retire or lose their pension. That means you're going to have 2 seats on the Georgia Supreme Court come open in the next term. So whoever the governor is will appoint 2 new Supreme Court justices. There's 1 on the Court of Appeals. And when you're talking about the Georgia Supreme Court, there are only 7. There are only 7 justices. So appointing 2 obviously has a huge impact. So that's a huge impact on the law of Georgia because obviously the Georgia Supreme Court and the Court of Appeals, we aren't policymakers, but the law as it comes out, you know, comes to us, the trial judges first. We're kind of down in the trenches, if you will. We have to make those calls. Sometimes we make those calls on we don't have a whole lot of time sometimes to make calls because we're confronted with legal issues sometimes, and we maybe have seconds or minutes that we have to make a decision on. And so we make those calls, but then they filter up. They get them and they analyze, and say, okay, no, that's not what that statute meant, or yes, it is. So you can see who the justices, and the Supreme Court justices and the Court of Appeals judges are makes a huge difference. That's also true with your U.S. Supreme Court, because there's been some speculation as to whether or not Ruth Bader Ginsburg would retire, and those are always appointed. So obviously, anytime there's an opening, it leaves open the opportunity for those appointments. So that's just something interesting for the next election, because it's been, in fact, both of the candidates have talked about what they foresee for the judiciary if they were to make those appointments. So it's a very serious issue. It's a very serious issue to us because it affects pretty much every decision that we make thereafter. So it's just something that I guess I hadn't really sat down and thought about it, but then I looked at the newspaper and I was like, oh, I see that. I just had not realized, because you get used to the justices and the Court of Appeals that you see there, and you forget that some of them have been there a while and they'd like to retire, and when they do, it leaves that opening and they have to be filled. So that's coming up. That'll be something that happens in the next 2 to 3 years. You'll start seeing those changes, and those will be, like I said, appointed by the governor. But then they do have to run. And they're for a Superior Court judge, for me, for example, there are very specific requirements that you have to run. So obviously you have to have a law degree. I have one, which was obvious. You have to have that law degree. But the second thing is you have to have practiced law for at least 7 years to be constitutionally qualified, if you will, to be able to hold this particular position. That is not true for example, your probate judge and magistrate judge. In fact, in Georgia, probate and magistrate do not have to be lawyers in certain circumstances. Now, you go to Atlanta, they do. And you're going, well, why is that? Well, it's based on population size. So depending on what your population is, you may have to have lawyers as a probate and magistrate judge, you may not. In our circuit, because our population is small, they don't have to be. But if you want to be on the Superior Court, you have to have at least those 7 years, and you have to be in good standing, and that it's helpful if you've been in the courtroom, because I will tell you, it is a massive body of law. I mean, it is massive. Thank the Lord we don't have the tax code. I think I might have just said forget it if I had to learn the tax code or bankruptcy or something. That'd just be more than I could do right now. But but when you do civil and criminal is a pretty established area because it's so fundamentally based on the Constitution. So it's been, I mean, everybody's heard Miranda and all the things that have been out there for many, many, many years. It's very constitutional based, so it doesn't change a lot. It just gets finessed a little bit, if that makes sense. They'll tweak it. They'll take a modern situation. One of the newest things was if you're going in a car and you get pulled over and they search your car and they take your phone, can they look at your phone? Well, the answer is no. Not without a search warrant. So you'll see things like that are adapting to kind of the modern, things that pop up, whether it's computers, iPads, iPhones, whatever. Those types of things we'll get a little clarification on as we go. Civil, however, is a massive body of law. It is ever changing. And there's always something new going on. There's always some change to it. There's always some new cap that's been added, something. It is a massive body. So when you're dealing with civil and criminal, it's a lot of law. So that's why there's those constitutional requirements there that you have to have practiced for at least 7 years. Doesn't mean you have to be a trial attorney, but you had to have been a practicing attorney for 7 years. It helps if you've been a trial attorney because you've obviously been exposed to that. And attorneys are kind of like doctors. Most of them don't do everything. Most attorneys. When I practiced law, like I said, if you had said, Mandy, I want you to come represent me in this against the IRS, I'd probably laugh. I'd been like, are you nuts? You don't want me to know. go hire a tax lawyer. I ain't it. Because that wasn't my area. But I did do criminal and civil litigation, so it was not a shock to me when I got there. But it is an ever-evolving thing. You can never just sit down and assume you know it. You can't. It is impossible. I have with me at all times, in fact, they're in my car right now, I have 5 books that I always carry with me because they're kind of the most up-to-date evidentiary rules. And we have had In the last couple of years, we had a massive, in fact, complete rewriting of our evidentiary code. Complete rewriting of the evidentiary code. That throws some folks, because they've been practicing the same thing for a long time, and then all of a sudden, it's completely different. And it's not one thing, it is the entire code. And it is, that you talk about having to sit down and literally like be back in law school and read it all over again, because it is vastly different. And we didn't just decide we were going to do all federal rules of evidence or all Georgia rules. We have this kind of combination of both. And so you can't just say, oh, that's what the feds do, that's what we'll do. Kind of, but not really, because Georgia put their own little spin on it. So that, all of those cases, frankly, are up on appeal. So we don't necessarily know how that's going to trickle down in some of those instances, because our appellate courts have not looked at every issue that's popped up yet, because the code is that new. We've also had a complete, and I don't do this. This is not my area, but we've also had a complete rewrite of the juvenile code. Complete rewrite, which in and of itself is a very complicated code. I mean, probably as complicated as tax code, in my opinion. It is juvenile law is very, very, very complicated. Complete rewrite of that as well. Judges go to school. We go to school. We go to school twice a year. I do twice a year, because it is imperative that you never get too comfortable. If you get too comfortable, you're going to make a mistake. So you have to always be reading. You have to always be looking, you know, and it is very, I have next to me at any given time, I have an iPad, you know, a laptop, and I'm pulling cases up as we go, sometimes mid-objection, because I'm going, okay, this particular set of circumstances doesn't necessarily fit this, and so I'm trying to look at it as I go to see if anything's been decided on a point like that, because some of it is very crafty. As you can imagine, lawyers are very crafty, and they come up with things sometimes, so you have to go, okay, well, that's new. I hadn't thought of that before, so then you have to kind of see if there's anything on point, and I do not leave home without it. I would probably have a heart attack if I didn't have access to the law while I was sitting there. We might actually have to stop, because some things are just that complicated, and it would be impossible to learn every bit of it. You know, a lot of it, like the evidence code and that, we've just sat down and had to learn it. But how we interpret that, and how they will be interpreted under the new evidentiary code, that may change, because some of those things are going up and it's all brand new. And they've told us to look to our 11th Circuit, which is obviously our federal courts of appeals and that. So those go up, and there's been a lot about that in the news lately as well. Those courts have been using a kind of a combination of this law for a long time, and so since we don't have any precedent on point, they're like, look and see what they did and figure it out. But that's about all they can give us right now. So it's, you know, it's tricky, it's fun, it's one of those jobs that the responsibility weighs heavily, and I think if at any time it ever doesn't, then you probably need to quit, because I think, frankly, it's a very intensely responsible job, and you make some decisions, and you can never lose sight of the fact that the decisions you made, no matter how big or how small they are, can absolutely affect lives for sometimes generations to come. And that's a very humbling thing for me to understand that responsibility is on me. And I never want to stop learning. I never want to stop trying to make sure that I am as current and as up to date as I am, because I am acutely aware that every single case is an individual case. And you know, some people are like, well, you know, these facts, haven't you heard these facts before? Yes, in a lot of cases I have, but not for you. And not for you. And what works in this situation, maybe this fact is a little different for some reason. And that judges, you know, unless there's no jury, we're not necessarily the fact finders, we're the law appliers. We don't find the facts unless there's no jury. Then we're the fact finder of certain motions, then we are. Juries are fact finders, we just apply the law. But if there's no jury, then we're the fact finder, the law applier, the sentencer, all of the things that come into play. And those are very heavy decisions sometimes. And so we have to be very mindful of that, I think, as a judiciary. And I think it is a responsibility that I don't take lightly. I don't sleep well sometimes, because I wonder and think about certain decisions that I have to make, and I know I have to make. But again, like I said, I think if I ever don't feel that way, then I probably need to quit. Because I think if compassion is a key, because the things that you see and you hear and you have to deal with can be so tragic and so heartbreaking sometimes. You know, parents can't get along and their kids are being taken away from them. You know, a child's been abused, somebody's been hurt. There are any number of things that you can hear of, and it is so important for us to number one, remain compassionate, remain patient, and understand that while we hear things all the time and we make decisions all the time, and sometimes it's very easy to go, no, that's not how that works. This is what we're doing today. I've done that because if it's something I do every day, no, we're not doing that. But the idea is some people just need to be heard. It is that I just want to be heard. I want somebody to listen to what's happened to me. I want somebody, you don't even have to agree with me, just let me be heard. And I think that's what we are as the judiciary, is to give people that opportunity to be heard within the confines of the legal structure. And sometimes the legal structure is not conducive to that, because there, like I mentioned earlier, some of those motions that can cut things off early, that can cut off some of those opportunities to be heard. But there are very specific processes that we follow for that. Short of that, it's the opportunity to be heard and to have an open and public courtroom. You can walk into my courtroom anytime you want to. You can come and watch anytime you want to. You can't ask questions anytime you want to in the courtroom, but you can certainly come, you can certainly observe, you can see the business that goes on in the courtroom, you can watch any of the accountability courts, and if y'all haven't done that, that is something you should watch at some time. Come to a graduation, they're amazing. And I don't want to get off on that too much because I could literally talk for hours about those, and I'm sure Judge Weaver did, because like I said, they're super important to us. But those, we do some of our, I think, greatest work in those courts. When we get somebody who's been addicted to drugs, they're retired, since they were 10 years old, we get them clean, we see them with their families, we get their kids back. So we see people that have gone with undiagnosed mental health issues and have made some terrible decisions, not because they're bad people, but because they never knew what was wrong with them, and they never knew, there's something I can do to help me with this. And we get that help to them, we make sure they're going to the doctor, we count their medicine. I'm sending my case makers going, do they take their medicine? They are out there counting their pills, making sure that they're taking them, and they literally do. They go and they count them. And then we get an email saying, Judge, they counted them. I get them 24 hours a day. Judge, they're taking them, they're doing this. When you see those folks who had literally did not ask for the circumstances they were dealt, basically, and they are having healthy, productive lives, they're reunited with their families, they're reunited with their children, they aren't taking, drugs to self-medicate, they are doing all of those things, they have jobs, they're being productive, sitting, that's some of the most rewarding work that we do. And when we get to do the graduations, they're truly amazing. To hear those people come in and speak and to tell you about their lives and tell you the struggles that they've had, you find out they're just people. And they want the opportunity to do well and be well. And we've determined that, sometimes really good people do some not so smart things, but that doesn't make them bad people. It just means that they made some bad choices. When you are a drug addict, you are an addict. And people, they're like, oh, Judge, why are they in your drug court? They all they've got is theft crimes. Yep, because they're stealing to go buy their drugs. Not because they want to, but that's what they're doing. They're stealing to go buy the drugs. And there has been a huge push. I know y'all have heard about a huge push in the last 2 to 3 years to pick out, because not everybody fits into this category. There are some people that need to be in prison. Okay? There is no other place for them. They're going to prison. That's who prisons need to be reserved for. Georgia is not the biggest state in the nation, but we have, I think, the 4th largest number of people, and it may even be more, but we have the 4th largest population of people under the Department of Corrections. Which means, do you know what the biggest portion of Georgia's state budget is? The Department of Corrections. It is the biggest portion. Nothing else even comes close to it. And I wish I had them, because we were talking to them just a few weeks ago, the amount of money that has been saved to counties, to the state itself, focusing resources on treating these symptoms and saving the prisons for the violent offenders, what we would call the 7 deadlies: murder, armed robbery, rape, aggravated child molestation, things that are just so bad there's no other place for them to go. If they're convicted and they either plead guilty to or are found guilty of those offenses, they go to prison. And they go to prison anyway in those cases, because they're mandatory minimums on those sentences, meaning that it doesn't matter what I think or what I want to do, state says you must sentence them to no less than this, and so they go. Those folks need to be there. The people that have addiction issues and mental health issues, and they're doing smaller things, but they do it a lot. You know, they're criminally trespassing 10 times a week, or they're going in and stealing, water because they've gotten onto some drug and they're dehydrated and they're dying for water, so they go steal water. Those are the ones that we try to move out of that system, get them into the treatment, and save those prison beds for those who really need to be there. So, any questions? I feel like I've gone all over the place here, but just trying to give you an overview of what I do. It's just there's just a lot going on at all different times. So questions, I'm happy to answer if I can. Yes, sir.
Okay. Who was responsible for those massive changes in the evidentiary code?
Lots of people. That has been coming for years. It started, I want to say that people have been pushing for that maybe since the 80s, and it has taken a long, long time. But we had two main entities that were kind of going at it. Then we had kind of the person that authored them, kind of the person who's our expert, if you will, in Georgia on evidence. This Paul Millich, he's an evidence, I think he's a professor actually, but he had been advocating, and when he was teaching law students, basically saying these are not going to work. We need to change that. So basically PAC, which is the Prosecuting Attorneys Council, and then the state bar, within the state bar of Georgia, the state bar being all attorneys are members of the state bar, and within the state bar there are different basically groups of attorneys. You know, you've got your real estate group, you've got your family law group, you've got your trial lawyers group, you've got your defense group. You had Georgia Trial Lawyers Association, which is typically your defense attorneys or your civil litigation attorneys, and then you have PAC. All of them coming together, and as you can imagine, when you have people on completely different sides of the aisle, the word compromise was probably pretty good, because there were some definitive compromises made, because as you can guess, between the Prosecuting Attorneys Council and defense attorneys, there was some definitive disagreement, if you will, on what they thought those rules should be. But they had guidance from some evidentiary experts, and they sat down through lots and lots and lots of negotiation, kind of hammered out, and it didn't work the first time. They tried several times before they got something that everybody was happy with. Well, happy in the sense that they could live with, I guess is probably a better way to say that. And then it ultimately passed. You know, after they got it kind of figured out what they wanted to do, they took it to the state reps and said, you know, your members of the Senate said, this is what we want, this is what we think is best, and it passed. Same thing with the Judiciary Code. They rewrote it, same thing, people sitting down, and it involved judges and lawyers and lots of different people with lots of different input, lots of different aspects, 50,000-foot view, not just a little view, to make that work. But it is very new. It's very new. So we're still kind of, you know, looking at it and hoping that, you know, we'll get some kind of interpretations on that. But right now, I look at something, I read it, and based on whatever I read, I make a decision. And if that decision is right, it's right. If it's wrong, somebody above me tells me it's wrong, and then I fix it. Any other questions? Yes, ma'am.
I'm going back to the next governor appointing.
Yes.
Do those appointments have to go through the House legislature?
No, that's an excellent question, and I can tell you from firsthand experience because I had to do this. If you are appointed if somebody retires for whatever reason and there's an appointment, a judicial appointment, the governor will appoint. There is a judicial nomination committee. It's the JNC, basically. And it consists of, I'm not totally positive how many lawyers are in there, but they're from all over the state. Primarily, I think when I did, a lot of them are from more of the metro counties, but there are tons of them. And you walk into a room, and you are at a table that if you took all of these tables and put them end to end, that would be about the size of the table. And there are that many lawyers in there, and now I'm looking at you. and they will rapid fire questions at you, kind of like what you see nowhere near as intense. I do not mean to say that it's intense, but it feels that intense when you're doing it like a congressional vetting, basically. That's basically what they're doing on a smaller scale. They are vetting you, and those attorneys are from all different walks of life, all different practices, and they are rapid firing questions at you, and I do mean rapid fire. I felt like I was in a tennis match, except I was a tennis ball, because it was like this. You know, I'd answer one question and somebody would fire another one at me. And what happens is when that opening comes up, people can be nominated to fill the position. A nomination doesn't guarantee the position, but it gets you into the list. Then everybody that submits that questionnaire then goes through that vetting process on that committee. That's long before it gets to the governor. Then once that decision is made, then they will take, say, I can't remember how many were on the list when I was there, but it was probably 15 or 20. They will narrow that down to however many on the short list, and there's no statutory requirements. It can be 2, it can be 10, it can be whatever. And then that list is provided to the governor, and then the governor interviews those individuals, and then he ultimately has the decision to make that decision if he wants to. And that's how it occurs, and that's true for all of those. Obviously, as you can imagine, though, when you get to the Supreme Court and the Court of Appeals, those are very seriously vetted, because those are your high schools of the state. Any other questions? Yes, ma'am.
Okay, well, Ralph kind of asked the first question I had, and the legislature does have to approve it.
Yes, they passed them.
Okay, but my other question is, having been called for jury duty several times,
Yes.
I didn't have a job and I could go, but I feel sorry for the 30 or 40 people that had to take off work. And we sit there, and they only have 4 or 5 cases scheduled, and they wind up pleading guilty or something. There's no trial. And the county has to pay for each one of us that have been sitting there.
That is correct.
Can't they schedule more than 4 or 5 cases?
Well, the thing is we do. You know, I can give you how that happens to some extent. And the truth of the matter is the judges, your judges in this circuit, are very, very cautious about calling in juries. Because we are acutely aware that that happens sometimes. I am a little bit, maybe, I'm very time management sensitive. All right, I am always on the bench probably an hour before court starts, and that's only because my pencils have to be lined up. I got to have everything I need where I need it. And if I'm 15 minutes early, I'm late, because I am I know that. I may not pretend, but I know that about me, so it's okay. And in fact, everybody's gotten used to me being that way now. So I am very, very mindful of your time. So are the judges. What happens though is, I'll give you an example. I've got jury trials that start next week. I numbered, I think, 103 cases. There are 103 cases. As of last Friday, do you know how many are left? 30. By the time I get through tomorrow, there may be half that. But if I have one person that wants a trial, particularly in a criminal case, it is absolutely, without a doubt, vital that I call in a jury for many different reasons. One, we are subject to trying cases quickly once they become ready. But sometimes somebody will file a speedy demand. Well, if they file a speedy demand, it's got to be tried, period, unless it resolves. And it may be the only case we have. But we try not to call them in. If we don't have more than one case, something to back up after that, we try not to. But if I have 2 attorneys that come in and say, Judge, we're ready to go and we're going, and they've demanded a jury trial, I absolutely have to give them that jury trial, because otherwise 2 things are happening. One, I'm not doing my job, and I'm not necessarily protecting the Constitution that I swore I would, because they are absolutely entitled to that jury trial, particularly in criminal cases. That is not a case in civil cases. There are instances where you don't get a jury trial in civil cases. You know, Georgia is the only jurisdiction left that I can think of that even allows a jury trial in divorce left. Many states have gotten away with that. I mean, they just said no more jury trials and divorces. So not everything in a civil case gets to a jury, because they're not entitled to one. In a criminal case, no matter how small it is, it could be running a stop sign. You can get a jury trial if you want one. It's just, you get 6 jurors instead of 12. And if they come in, we have to give it to them. But we start out with a good, I started out with 103, and I am down to 30. And by next week, I may be down to 5. And I will have a jury there Tuesday morning, and I will say, okay, who's first, and I'm going straight down the list. I will come in, I'll say, is the state ready? Yes, Judge. All right, is the defendant's ready? Yes, Judge. I will go impanel the jury, and I will come back, and I may get, we want to plea now. Okay, then we'll go plea. Next case, same thing happens again, and you know, and I totally understand, because it's frustrating. And the interesting thing I've been called for jury duty many times. I don't know how that happened. I even got called after I was a judge, which I thought was kind of interesting. Obviously, I know stuff. And I can't imagine why anybody would want me on jury. But it has happened, and I got it a couple of times. And it is frustrating, because I was sitting there going, well, this is interesting. Because I have court somewhere else, and I'm supposed to be here, so this poses some interesting ideas here. But, you know, I understand that it is time consuming. I also know how much it costs. Trust me, not a day goes by that we don't try to minimize those costs. We are very, very conservative. If you go back and look, you will find that, and I had a jury trial in Fannin County just a few weeks ago. It was a criminal case. But we don't have them unless we just have, that's where we've gotten to. But if the attorneys come in and say, we cannot settle it, Judge, this is where we're going, and they're entitled to and have demanded a jury trial, then we have to give them one. Because if not, we violate a whole bunch of rules, and I don't want to have to explain why I violated that rule, because that's just how it is. But we do try not to do that, I promise you. If we think the attorneys are bluffing, it wouldn't be the first time that I said, I think you're bluffing. Not that many words, but kind of, you know, I think y'all need to go sit down and talk before we bring in this jury. And sometimes just me going, y'all need to go sit down and talk, that they will, and that will be the end of it. But sometimes we have to.
One short question.
Sure.
What about Spanish-speaking people? Do you speak Spanish? Were there lawyers? Do you have a translator? What happens?
We have to. We must. It doesn't matter what they speak, whatever language it is. If they come into the courtroom, I don't have to speak the languages, thank the Lord, because if I did, I've got a southern accent, they probably couldn't understand me anyway. But we must accommodate, and it is not optional. We must. It is a shall, not a may. So if for example, I've had that. I've had a trial where we have to have interpreters. That is very expensive. That's probably one of the most expensive costs of a trial, because understand that it is not one interpreter. It is many. Because the rules say one can't do. You must have many. Because it is so critical of what's being translated or interpreted, I should say, that they get tired. They have to have certain breaks. Somebody has to come in and basically fill in for them. So somebody has to be interpreting for them. But then if there are witnesses, in addition to a party who doesn't speak English, whatever that language is, there have to be interpreters for them, because somebody has to be interpreted over here. So one non-English speaking person would probably take 2 to 3 interpreters for one trial. But we have them, and we get them. And sometimes it's difficult because the dialects are sometimes different. And sometimes we don't have anybody that speaks that particular dialect, so we have to call, South Georgia or, Rome or wherever and say, hey, do you have any interpreters down there that speak this particular dialect? And then we have to get them up there to do it, because not every interpreter speaks the same dialect. Spanish, there are multiple dialects, and just because you speak one does not mean that you understand, because it's colloquial, and so we have them. She was in court with us today.
It's like somebody from Boston trying to translate my Hebrew.
Yes, it is, and you know what? I can appreciate that, because I went to law school. This is rich. I went to law school at Syracuse University, and they thought I had an accent. I didn't appreciate that. I was like, I have an accent. At least I know how to say, whatever, because they used to make fun of it all the time. So I understand, but it is true. They, we have to have them, and we do. Any other questions? No?
I have
Sure.
one, and I guess I'll be the last one because
Okay.
we're really out of time. But it's always really bothered me that the ability to be heard in court seems pretty directly connected to how much money you have and the ability to hire lawyers and so on. And maybe there's no way around that, but the justice that somebody gets without enough money to hire lawyers seems way different than what somebody that can hire the dream team gets.
Well, I will say this. In civil cases, I'll start there. In civil cases, you're not entitled to have an attorney appointed to you if you can't afford one. You're just not. That means if you have a civil case, whatever it is, and you feel like you need a lawyer, you got to hire one. The only exception to that are court-appointed attorneys in juvenile court for defects cases, basically, where children are being removed. Attorneys are appointed in those cases. But if you are in a civil case in Superior Court, there is no such thing as an appointed attorney. None, which means you have to foot the bill for your own. I will tell you, it can be intensely expensive. And how expensive it is depends on, one, on what type of case it is, and two, how contentious it is. If you happen to be in an incredibly contentious case, and there's a lot of things going on, and that attorney is billing, whatever they're billing, and you're sitting in court for 5 hours, it gets expensive very quickly. As a result of that, in the last 5 years, our civil caseload has gone down some because people truly have not been able to afford a lot of different things. I mean, they just haven't. So we've seen our civil trial calendars, jury trial calendars, going back to your question, dwindle away in a lot of cases because juries are expensive. Now, in a criminal case, not the same. In a criminal case, you may not get the lawyer you want, but you do get a lawyer. If you are in danger of being incarcerated, even in your county jail, you get a lawyer if you can't afford one. And I probably say it 100 times a day. You're going to represent yourself. You want to hire an attorney. If you can't afford one can be appointed. If you qualify, here's the paperwork, fill it out. Sometimes I'm appointing them an attorney because they need one. And I've done it, I don't even know how many times. Because sometimes they don't want an attorney. Not wise if it is a really complicated, very serious case. We always, do you want an attorney? Hoping that they want one. So in a criminal case, you're going to get an attorney if you want one, period. Because we'll get you an appointed one. Because when your freedom, when your ability to go to and from a place is at risk because you could be incarcerated from one day to the rest of your life, it's that critical. But as far as the dream team of attorneys, that's limited only by what you can afford, and you're correct. If you want Robert Shapiro and Bobby Lee Cook and F. Lee Bailey or whoever it is, Jerry Spence, whoever it is you want to represent you, that's going to cost you probably a lot of money because they're going to be like, well, we have to come over to Georgia and do this. But if you have the financial means and you can hire them, you can hire whomever you want, so long as there's no conflict.
Well, we're nearly out of time. Are you willing to talk a few more minutes?
I'll do whatever you like. I can answer questions as long as you like.
Let's try just 2-3 minutes.
Okay?
It sounds like the state would pay for a public defender, but in Fannin County, the person who's been accused has to pay their public defender whatever the judge decides.
No, not exactly. The state does, but we have public defenders. There are some jurisdictions in Georgia that opted out of the statewide public defender system because they were one county. Cherokee County, for example, is a one-county circuit. They opted out of the public defender system, so they use private attorneys to do their public defending work. Basically, they have a list of people that are willing to come in and do their cases. They do it at a cut rate. In Fannin County, Gilmer County, and Pickens County, we have a circuit-wide public defender. His name is Mike Parra. He is the public defender. He is of the state. What happens, though, in a criminal case is that even though we say you get a lawyer if you want one, there is a fee. If it's a misdemeanor, it's $300. If it is a felony, it's $500. But that becomes part of their sentence, and it's basically restitution to the county that it comes from. So as part of the sentence, I don't have discretion as to what that amount is. There's a specific schedule of it, but it becomes part of their sentence. What that means is if they don't pay that money back, it's an accountability thing, frankly. But if they don't pay that accountability, they've got to pay for at least something back. Of course, for a private attorney, they might, be billing $50,000 or $60,000. For a felony, no matter what it is, it's $500.
Even if they're found not guilty, Judge?
No. And if it goes to trial, I think it can be a little more than that. And if it's a death penalty, that's off the table. That's a whole different thing. Well, I didn't even get to the unified appeal process. That's complicated. But as a general rule, we say in every plea I take, if they're represented by the public defender's office, you owe them $500 for your case. It becomes part of their sentence. If they don't pay it, they can go to jail for not paying that because it's part of their sentence. But it's a set fee.
Thank you so
There
much.
you go.
I don't think so. I have to say, when is it you remind me of the Everlast Bunny? I just can't.
How do you get the energy to keep going every 1 hour a week?
Yeah, sir, Lord,
You know, it's what, I will say this, I realize I look 12. I know that. And it's funny, when I charge the grand jury, I always have the jury, I'm like, okay, is everybody here over 18? And I know they're all looking at me going, yeah, but are you? And so, but yes, I am. But, you know, I love what I do, so it's easy for me to keep
she's
going.
a blue streak going up down the hallway.
Thank you so much.
Thank you.
And you're welcome to stay throughout the business or whatever.
Whatever, if y'all want me to say, I'll be happy to take questions afterwards, even if there's something you need to get, if you just got a burning question you want to know the answer to, if I don't know, I'll make it up.
All right, is there anybody who would like to ask her to do that? Okay, then it's up to you and you're welcome to
Okay, let me
stay.
see, is it gonna be maybe another hour or 30
Maybe
minutes?
another 30 minutes.
Okay, I can stay for a little bit. I gotta go home and do homework with my daughter at some point.
All right, good. Is there anyone here who does not have a copy of the treasurer's report in the secretary's minutes? Okay. Doug, would you want
Is that what you're doing now?
just, I'm about to, when everybody looks there. Okay. We hope that you will come in and read those two reports so that you don't have to read them during the meeting. So I'm going to go ahead as if you have done that. Let's look at the secretary's report.
Peggy, be sure to talk right into that thing because your voice is.
Okay.
Thank you.
Can you hear me?
If you talk right into it.
Joe, can you hear me? Can you hear me if I talk like this?
Well, when I had my back turned, I didn't, but yes.
Okay, I'll do this, and if I let it down, you just tell me to let it back up. All right, I move that we accept the minutes as presented by our Secretary Bella. Is there a second?
Carl second.
Second. Any corrections or questions? Okay, those in favor? Aye. Any opposed? Thank you. They are accepted as presented. If you'll turn the page, you'll see the treasurer's report from Joan, who is our treasurer. All right, I move that we accept the treasurer's report as presented by Joan. Is there a second? Okay. Any questions?
I did want to add something.
Oh, yes.
Yes, I wanted to add, for those that didn't see the treasurer's report the previous month, we have paid the county a deposit of $300 for each of the 3 candidates, which is a total of $900, but it doesn't show up on this. We have paid the state of Blue Ridge, the city of Blue Ridge, $200 for each candidate, each of the 3 candidates put our signs up. And we have more money going out this month, October, which doesn't show here. As long as we get the campaign signs picked up within a week of the November elections, we get that $1,500 back.
All right. Any other questions? All right. Those in favor of accepting the treasurer's report as written?
Aye.
Any opposed? Then we accept it as written. Thank you. We have one item of business. It's not really a big item. We have a change usually in our meetings on the election months. At our next meeting is election day, and when I fixed this agenda, all of the committee members had not voted. They have voted now, so let me tell you how they voted, and I'd like your feedback about that meeting. We had 3 choices. Since our meeting is on election day, the choices were to delay that meeting 1 week, to have the meeting later the same day and have it serve as an election party without a regular business meeting, and the other was to cancel the meeting for a month. On the committee, we had delayed the 1 week, 1 person election watch for cancel 2. So that's not a great majority, and all the committee members did not meet. So I'd like to know a little about what you think you'd like to do for the November meeting. And if, yes, Carl.
I'm okay with either of the first two solutions. To cancel it, I don't think we should do because we ordinarily don't have a meeting in December. We have a party in December. So that would mean going all the way from now until January before we meet again as a party.
All right.
So I don't think we should cancel it. I think we should
Okay,
postpone
three
it.
in there?
Well,
What was yours?
I was talking to somebody today and thought that it would be a great idea to do, on the voting day and just have a gathering here and watch the
Like
results.
we did before.
Yeah, that was.
Okay, if there's no objection to that, then I think that is the majority of the vote. So we will need to set a time because we will need to come later. What time do we start getting election returns? 8?
Sometimes as early as, just as soon as our bags come in, we start tabulating them in the back through the little disc.
Yes.
And so sometimes we're finished by sometimes the 9:30, 10 o'clock. But this being a general election, it'll probably be 10 o'clock.
Okay.
On November the 4th, and I got to work from 6 o'clock in the morning all the way probably to midnight.
All right. Shall we say 8 o'clock? Is that okay? 8 o'clock.
8 o'clock.
And bring snacks.
Popcorn.
No, they did popcorn will be fine. I guess they won't let us bring champagne or something if we lose. Maybe not.
Moonshine.
All right. Then we will have the election party beginning at 8, and I'll ask permission to do that as we leave this evening. All right, we have announcements. Lena?
Okay. It'll be short and sweet.
Please.
I get up. No, I don't need that.
Yes, you do.
No, I don't. No, I don't.
John, and Carl, and Bill.
All right.
Carl, you'll have to do it.
I'll go
with
right
Lena.
next to her.
Okay.
Bill, can you hear me? Okay, I'll yell. All right, I'm gonna make mine real short and sweet. We'll start voting next Tuesday, early voting. Okay, we vote all the way through to the end of the month. So we have one Saturday, not this next week, but the next Saturday. So we will be voting from 9 to 5 except for that one Saturday. The board has decided instead of 9 to 4, we are allowed to change it to 9 to 5 because so many people work. So we've had a better turnout. So as between just last election and this election, we have registered 88 new applicants in 1 month. And we have, like I said, next Tuesday, we start early voting. And the polls are closed as far as people registered. That was November to October 6th. That was the last day registered. But if anybody's got any problems or need any applications, please call the office and we will mail them to you. So if you want to vote absentee, but be sure and get the people out to vote because we've got an awful lot of shut-ins that need applications. And I have been getting phone calls and I'm getting them mailed out to them. So, but I go through the office. I don't do it myself. I go to the office and do it as a registrar. So that's short and sweet. Thank you.
Lena, can we ask another question? We heard earlier that there were a lot of people who thought they had registered, but then found out that their information had not been processed. If that happens,
Call
what do we
Mary
do?
Ann and she will check it and see what's going on. She'll call the state.
Okay. Did you hear that? If you know of anybody who believes they've registered, found out that it hasn't been processed, ask them to call Mary.
Our main problem up there is the, out at the highway department, I mean, not highway department, but out at the where they register when you get your driver's license. Half of the time, they do not ask the people if they want to be registered. And then people think they did because they were told they could get registered out there when they got their driver's license. And when they get their driver's license, it says no on it. And so people are not fully informed on that, and then they come up to the office. And then a lot of times when they did say they wanted to, it doesn't even go through down the state. So they need, when you get a new driver's license, you need to find out and call, and Marianne will check to see if you're registered, because lots of times we don't get them, and it is a hassle, and people obsessed about it.
Thank you for that, and all of you, if you have an opportunity to
I
talk
think we should bring in citizen
about
action
that.
against people that.
Well, I
We're not doing a good
will
job.
also tell you, though, the driver's license thing has actually caused a lot of problems for people. You would, interestingly enough, you would not believe how many petitions to change names that I have had since they changed the driver's licensing, the way they did it, and what you have to have. First of all, if you haven't had to get that, you better start now, even if you don't have 5 years, because you have to have all this documentation. The problem is, though, is that if your name is slightly different from like your social security card, for people that maybe it was spelled a little funny, I have probably done 20 or 30 name changes in all the counties with people having trouble going to get their driver's licenses because it's not matched in the system. That was never a problem before, but whatever they're doing now has really created some problems. So it's a problem. It's difficult.
When you go to get your driver's license, you have to have a social security card. You gotta have that doesn't count, social security card doesn't really. You gotta have like a,
Birth certificate.
you gotta have something with your picture on it. Your old driver's license don't even count. You've got to have a passport picture or birth certificate, a marriage license, and at least 3 bills with your name and address on them.
Physical address.
Yeah.
If it's not a physical address, then
That physical address, you're correct.
It's complicated, so we need to learn as much about it as we can. And
I got to tell you what I did when I went and got mine in January.
Yes.
I went in with a stack of 10 pages.
Yeah,
You didn't look at me.
I had to do that too in March. Okay, remember.
What worries me about that is I had absolutely no problem. They took one look at me and ran me through it, as you said. If my skin had been black, it would have been different. That's what it's all about.
That's what it's all about. That's what it's all about.
Election day is the 4th. Make sure you vote. Make sure everybody you know votes. Make sure your neighbors vote. We have a person who's doing our calling for us, and she said just in her neighborhood, she had found about 10 people who thought they were registered, and they weren't, so she got them to the polls. So make sure that you get there and you take anybody with you who can. If you meet anyone who needs a ride to the polls, we do have a few volunteers. So if you'll call me, I will get somebody to pick them up. We have signs for the Democratic candidates, Vogel, Nunn, and Carter in Pete Thomas's yard. So he has the whole yard full of them. You are welcome to just go pick you up, whatever you need. Make sure you follow the law in putting them out. And ours have not been taken down again. So we play it fair. Yeah, that's nice. And we have not taken anybody's back, right?
That's my job the day after. Let's go around and collect all those.
We do need to set it down the day after election day. We still have some Vogel pamphlets, and we have Vogel's cards. Remember that he wanted us to give these out and just ask people to watch the video. That's all. We don't have to make any long speeches, just watch his video. I will say that he spoke at the Tea Party meeting last week, and he was marvelous. And several of them said that his talk was good, his points were good, and they were excited about it. He's a brilliant man. And I hope that he's getting a lot of name recognition, so I hope that's a good result from that. I have heard a couple of things in the last week that I want to tell you just to point out how much misinformation there is in our world today. And one of it was that the ACLU has a case against New Jersey schools for pledging allegiance to the flag because, quote, it might offend some Muslims in the school. That is not true. No, it is not. I have their information. I have the list of what they have in court now. It is absolutely false. And it came to somebody on talk radio. Let's remember, if we talk about events, to make sure we know what we're talking about. I heard again that the Veterans Administration was going to take the guns away from all veterans, and especially women, because they didn't think women had sense enough to shoot guns. That's not true. Don't you know that is not true? Except a whole room of people were buying it. Pay attention, and if you say something for people who are going to believe what you say, make sure you know what you're talking about. It is ridiculous to hear those kinds of things and have to rebut them. We were encouraged to attend the county commissioners' meetings, and so I put that on our schedule. It's the 2nd and 4th Tuesday at 6 o'clock in the courthouse. They want many citizens to come to those meetings. And a lot of important things are coming up there that impact us, and so let me urge you to go. We have 2 fundraisers for the Shop with a Cop campaign program. And I said copy program, that's my fault, it's copy. And one of them is a skeet shoot, which is October the 11th, and let me see. The other one is a basketball tournament, and it's on October the 18th. This money goes to feed hungry children in our county. And so if you are interested in participating in one of these, you have the information on your agenda. Please to call. And if you want to see any more information, I have it here. I can give it up to you. We are having our yard sale the 3rd week in October. Betty, you want to say anything about it?
16, it'll be Thursday. So loud now. Thursday, Friday, Saturday, October the 16th, 17, and 18. And the first of the week, I and some of my people that I'm working with will be at the pavilion, and we really need the support. Round up whatever you can and bring up. We would be so grateful to try to raise a little money for our party. And we got good, it was really great results from people bringing us last year. It was very, I think most every party member brought something, so we were very grateful for that. And thanks to all of you.
And thank you, Betty, for doing it year after year. Do we have anything else, any other announcements?
Charter school.
Yes, the charter schools. I knew when I saw your hand, I wanted to see.
You knew what it was.
I had put on here that there are meetings being held regarding charter schools in Fannin County. Joan has attended 2.
2 of the meetings, the other one was lady.
And she's having difficulty getting questions answered. And have I gone? No. There is one tomorrow night and one Thursday night at 6 o'clock at the Board of Education meeting. If you're really concerned about our schools, I urge you to go. I'm going to go tomorrow night. And let's see who the contract is with and what kinds of changes they're trying to make, because those things are not clear. So let me urge you to meet me there tomorrow night, and let's see if we can find out what the charter schools idea is all about, what kind of changes that will bring for Fannin County schools. Susan?
Yeah, just quickly,
You got a report.
I gotta leave.
Democratic women?
Yeah, Democratic Women, we're meeting again on the 25th, that's Saturday morning, 10 a.m. For those of you who don't have email, or check your email, Joan. And Judge Linda Davis is going to come to speak. So bring questions. We've got some things we've got to talk about, like we're going to make a year-end donation to a worthy nonprofit. So I need ideas and I need consensus of opinions. And we're also going to ask everybody to bring stuff for the yard sale too. And so we've got some things we got to talk about and how we can help lift this organization up. So 10 a.m. Bumblebee.
Thank you, Susan.
Be there for that.
Hope you'll be
Saturday.
there. Any other announcements, questions?
Can I just add one thing?
Sure.
I'm sure everybody knows, I don't think I said it, Pete Thomas's Pavilion. Pete Thomas's Pavilion.
Yeah.
Anyway,
She's saying that the yard sale will be at Pete's Pavilion. We all know where that is, and we, of course, will have signs out there so you can see. Anything else? Bring in there.
Full eclipse of the moon tomorrow.
Great.
Full eclipse in the morning. Get to a high place. It'll be in the morning starting at about 4:30. And it'll be full eclipse by about 6:30. So that's tomorrow. Yeah, big day.
Finding a high place around here shouldn't be a problem. Yeah. All right. Thank you for coming. We will have the passing of the hat, but we're going to borrow Bobby Dobbs.
Got the biggest head.
Okay.